Well, it's quite significant because, as you know, this case has had a checkered history, starting from 2010 when the gas supply and processing agreement was signed, up to the decision of the tribunal in 2017, which was the final quantum award, and then up to the decision of Sir Roscarlston of the Commercial Court.
Just stick with Buhari at the moment. Do you praise him for doing that? Was that a good move for Nigeria?
Yeah, absolutely. It's a critical move because it actually gave the Nigerian authorities the leeway to conduct thorough investigations into the signing of the agreement, and of course to make certain applications in the United States, which the court gave some decisions that then uncovered certain monies paid into some accounts, and then this was the evidence that was supplied to the court when the investigation commenced in 2018, that then led the court to find that there was a prima facie case of bribery and fraud and corruption, and of course led the court to give the decision for Nigeria to challenge the award.
Let's talk now about this Cranston decision. How significant was that?
It's quite a significant decision, because although Nigeria commenced the investigation quite late, that is, Nigeria became more aggressive in 2018 when, after the awards by the tribunal were given, the decision is actually quite significant because this is what Nigeria is now, banking on in the Commercial Court in its application to finally set aside the 3 awards: the Jurisdiction Award, the Liability Award, and of course the Damages Award.
Would you say the Cranston decision was a turning point, if you like, that suddenly the Nigerian government was back in the game, wasn't it?
Absolutely. I would say the decision is quite significant. It's a turning point because, if you look at it, P&ID has actually gotten enforcement of these awards, until the Cranston decision. I haven't found some new evidence, although as the judge also said that this case is unprecedented, so decisions of the arbitral tribunal should be final and binding on the parties, and as the court said that Nigeria didn't have this evidence that it now advances, which is one of the reasons why the court gave Nigeria the opportunity to bring these challenge proceedings in court.
Would you say that we wouldn't be where we are today if it hadn't been for Judge Cranston?
Yes, I will agree with that and say if not for the judgment of Cranston, we won't be where we are today, because at the court decided that Nigeria's case has no merit, then the award will have gone ahead to be enforced, and the enforcement proceedings will commence and will continue. But due to the judgment by Sir Roscarlston, which gave Nigeria the opportunity to challenge the awards, that is where we are today, and which is currently pending in the Commercial Court.
How much do you think is the English legal system on trial here as well?
Yes, the English legal system is actually quite helpful, and I wouldn't say it's on trial at all, because it's been quite an helpful legal system in actually making clear these processes, because this is an international arbitration that was decided by an international arbitral tribunal of repute. We have 2 former British judges and of course a former Nigerian Attorney General. So Nigeria ought to have made the challenge of corruption and fraud, which it's currently making, before the tribunal. But it may appear that Nigeria doesn't have the evidence, which it now advances. Right. So, but the English legal system shows that it gives the opportunity to a party that has uncovered evidence of fraud and corruption to bring such claim before the court and to seek justice. So yes, that is the effect and the opportunity that the English legal system has given. But then, of course, this case shouldn't be in all cases. It should be in rare cases, because we also need to understand the finality of an arbitration award internationally. So we have to thank the English legal system for that.
One last question. I know you follow the case very closely. Is there anything that worries you and troubles you about the way that it's been conducted from beginning to end?
I think the case has been conducted absolutely perfectly, because it has been given the necessary time and attention which it requires. The judgment, the trial itself was given a span of 7 to 8 weeks, which we recently just concluded in March of 2023. So it was given the adequate attention, and I'm sure that the courts will give the right decision, having examined all the facts before the courts. So the case is currently before Justice Robin Knowles of the Commercial Courts, and I also attended the hearing myself personally. When one of the hearings I also attended, and the judge was very careful in listening to the parties and giving the parties time and attention, and I'm sure the court will give the right decision at the relevant time.
What's your sense of the way it will go?
I can't say because the case is still in court. So, and we trust the court to make the right decision, having examined. We understand that the parties have made their claim and they've presented their arguments, which are both extensive and comprehensive, and I'm quite confident that the judge will give the right decision at the right time.